Rule 60(b)(6), Fraud on the Court Overview. Hello everyone. Welcome back to our Legal Knowledge series. Today, we're going to discuss an important concept in the legal world, fraud on the court, as it relates to Rule 60(b)(6). Our discussion is on the topic in general, and it is more a presentation of the pragmatic than the academic. Part 1, the definition. Fraud on the court is when an officer of the court, like an attorney or judge, has committed fraud during a proceeding in their capacity as an officer of the court, impacting the impartial functioning of the court system. Part 2, key elements of fraud on the court. This type of fraud isn't the everyday kind of fraud as it involves several unique key components. Firstly, it must be committed by an officer of the court, meaning someone who holds a professional role within the court system. Secondly, this fraud must be material, meaning it could potentially impact the outcome of the case. And lastly, this fraud must be intentional, meaning it was not merely a mistake or oversight. Part 3, examples of fraud on the court. For example, a lawyer who intentionally lies to the judge about a key piece of evidence, attempting to manipulate the case's outcome, might be committing fraud on the court. Or perhaps a judge who intentionally hides relationships that could constitute a conflict of interest. Part 4, consequences of committing fraud upon the court. Theoretically, the consequences of committing fraud on the court can be severe. Consequences can include a new trial, monetary sanctions, or even disqualification from practicing law. In some instances, it could lead to the final judgment being declared void. Very seldom does anyone suffer criminal sanctions for committing fraud on the court, but it does happen in cases of egregious behavior that cannot be ignored. Part 5, the reality of getting caught committing fraud upon the court. Large corporations and criminal prosecutors are more likely than not to commit the types of fraud on the court that go undetected or unpunished, even when detected. This is due to both the fact that parties with a large amount of resources are better at covering up their fraud or co-opting the forum wherein the fraud is detected, and the fact that such institutional actors come into court with an unspoken presumption that they have more integrity than their opponent. This unspoken presumption results in all but the most outlandish self-serving statements or proffers of proof being given little to no critical scrutiny in non-jury matters involving admissibility and sufficiency. Even in those instances where there is an undeniable fraud, most courts will go out of their way to explain the fraud in a manner that prevents consequences. A simple Google Scholar search of the case law of various jurisdictions will bear this out in practice. On the flip side, those accused of criminal conduct as well as those injured by corporate conduct are perceived by the various officers of the court as having less integrity or a reason to be dishonest. As such, criminal defendants and civil plaintiffs have their conduct scrutinized with an eye towards finding a reason to disbelieve positions or assertions of an opponent committing fraud upon the court. Many times the institutional nature of the prejudice results in a court going to extreme lengths to avoid finding a corporate defendant or criminal prosecutor has engaged in a fraud upon the court where the same is alleged by a civil plaintiff or a criminal defendant, even in the face of fairly damning evidence. Again, a Google Scholar search of case law databases quickly bears this out. Why is all of this relevant? Because understanding fraud on the court is crucial to maintaining the integrity and fairness of our justice system. Yet it is crucial to realize at the same time that it is not realistic to expect a court to be amiable to such arguments when made by civil plaintiffs or criminal defendants. Although everyone involved in the court proceedings should conduct themselves in a manner that upholds these ideals, there are instances where that is just simply not the case. Furthermore, those who do not intend to conduct themselves with integrity or fairness are often quite expert at hiding their intentions using various presumptions, arguments, or omissions. In conclusion, if you are trying to get a judgment set aside on the grounds of fraud on the court, as that term is used in Rule 60(b)(6), you absolutely need to be aware that there is very little chance of success, even in the most egregious of instances where there is proof that fraud on the court has occurred. This is not only the case where such arguments are made by attorneys for their clients but also, and exponentially so, where pro se parties are trying to advance such an argument. That is not to say that you should not try, but temper the attempt with the knowledge that institutional biases and resource availability work together to ensure that such set-asides are very few and even further in between. In fact, it is more likely that the party making such an argument will be sanctioned for making it than the argument will be accepted and relief granted. That's it for this topic today. Subscribe to our channel for more such enlightening discussions on the nuances of law. And remember, brothels tend to give out more justice than courts, and a court tends to provide a better screwing than any brothel.